the U.S. Patent and Trademark Office, the U.S. Patent and Trademark Office, we've been in existence for 226 years, with the signing of the first Patent Act in 1790. The very first patent examiner was Thomas Jefferson, so he was actually Secretary of State. So I like to say our backlog started early, because as Secretary of State, we had other matters to attend to as the country was forming, but also had to tend to our patent system. So the rumors were that he would keep the patents as they were granted in a shoebox, and then 2 shoeboxes, and apparently they were under his bed, and eventually he's like, you need a better process for organizing these. So now we have around 9 million patents that have been granted at the USPTO throughout our 226-year history. So not only do we grant patents, we also register trademarks, but that's not all. Our mission is not just to grant patents and register trademarks, we also are the principal advisors to the President on all matters of intellectual property. The head of the USPTO, her name is Michelle Lee, the first woman and first Asian ever to run the agency. We're very happy about that. She's actually my predecessor. She was formerly a director in the Silicon Valley office. Her title is really long. It's the Undersecretary of Commerce for Intellectual Property and the Director of the United States Patent and Trademark Office. So there's actually 2 titles in there. And then the deputy, just add deputy twice, and it's even a longer title. But there's 2 titles in there. One is the director of the USPTO. She oversees the 13,000 employees at the USPTO. But the first part of the title is the Undersecretary of Commerce and Intellectual Property. She does serve as the principal advisor for the executive branch of the government on all forms of intellectual property. So not just patent trademark, but copyrights, trade secrets, and really any enforcement of those rights as well. So there is a Copyright Office. Does anyone know where the Copyright Office is? It's in the Library of Congress, so it's not even in the executive branch, it's in the legislative branch. So we work really closely with the Copyright Office when it comes to domestic policy issues and also international issues. So we have a huge component, an international component of working with other intellectual property offices around the world. So what is intellectual property? So you may have heard me as soon as I saw this, I was like, oh, that's a patent. So I want to have all these t-shirts made up for my team that say that's a patent. Because literally wherever I go, we have an exercise later, if we have time, to kind of illustrate this point. But really, innovation is in everything around you. I was noticing these chairs, definitely patented, I'm sure. Obviously your cell phones have thousands of patents, trademarks, trade secrets. We'll talk more about that. But really, it's not just, it's really any creation, there's a way to protect those creations in the U.S. Question? No? No. Feel free to ask a question. So, I'll tell you just briefly about the USPTO. We're 100% fee funded. We do not collect tax dollars. We generate revenue based on the fees that we collect for the examination and the examination and granting of patents and the examination and registration of trademarks. So that's great. We love being independent because people always look at me and say, oh, there's your tax dollars at work. I'm like, no, that's not how it works. We have been named one of the best places to work in the federal government. A few years ago, we were 172nd best place to work out of 300 agencies. And in recent years, we were the first the best place to work, and now we have 10. So we're still very, very happy to have transformed our agency in recent years. We'll receive over 600,000 patent applications this year. Half of those are filed from other countries, and so the other half are filed from within the U.S. Of those, almost 30% are filed from the state of California alone, and half of them from the Bay Area and Silicon Valley. So now you know why there's a regional office in the Silicon Valley. All right, so now talk a little bit more about our regional offices. Towards the end, we talk about some of the services and programs that we provide to the regional office, through the regional office. But I wanted to take a moment to talk through, going backwards. Okay. yeah, to talk through the different types of intellectual property. So I'm actually going to go to my exercise, my spoiler alert. All right, so I love to talk about intellectual property, and I always need a prop. So here's my intellectual property prop. Right? So if I covered the label, would you still know it was a Coke? Right? Probably. All right, so we'll leave that there for a moment. So really, this is one example. There's thousands and thousands of products in the marketplace that use all forms of intellectual property. I just think Coke is one of the most recognizable and understandable. So we can talk through the different forms of IP as we'll use Coca-Cola as an example. Utility patents are actually inventions, things that have a use, a utility. We grant patents on those, and I'll come back to that towards the end. Design patents, shape of the bottle, right? Is just the ornamental features or design, not the functions. The functions will be covered under a utility patent because functions indicate their use. But design patents, you get a design patent for really anything where the ornamental feature is the crux of the invention, whether it be the pointer here or the shape of a bottle. You can't import function into that design. It really is just design. Copyrights are books, photos, music, fine art, graphic images, videos, films, architecture, computer programs. Really any creation can be protected by copyrights. And copyrights are really unique, and I don't work for the Copyright Office, so I'm not a copyright expert. I've been at the agency now 27 years. Started as a patent examiner, so I can answer all your patent questions and some of your trademark questions and very few of your copyright questions. So copyrights, going back to the Coca-Cola bottle, what would be a copyright for Coke?
The logo?
The logo, right? The logo, the print of the printed label, right? The jingle, the Coca-Cola advertisements, right? Any printed matter that's promoting Coca-Cola is also protected under copyright. Right, trade secrets, formulas, methods, devices, or compilations of information which add value to a company as long as that company is able to keep that secret formula, method, device, or compilation of information, if they're able to keep that a secret. And so it really is a challenge. You may have even read recently an heir of Kentucky Fried Chicken allegedly gave up the KFC recipe. You can go to any internet site now and download the Mrs. Fields cookie recipe. So there are instances, many of them, where you try to keep something as a trade secret, and if you're not successful in doing so and it's in the public domain, you essentially have a potential of losing your competitive edge. So going back to Coca-Cola, everyone knows, trade secret, most popular one in the world, is the actual formula of the Coca-Cola product itself. And this is something where no one person at Coca-Cola knows the formula for it. They go to extreme measures to ensure that not only is it kept secret, and also protecting other people's from figuring out and discovering that secret. So trade secrets, if I separately come up with my own formula and it's exactly like Coke, Coke can't do anything about that. They can't go after me. If I've somehow reverse engineered, figured out the formula, they have no rights unless I stole it from them. Then they could go after me for criminal actions. But if they've taken reasonable measures to conceal the trade secret and I separately discover it or reverse engineer it, there's really nothing that they can do. So let's go to trademarks. Trademarks are really products in the marketplace, so words, symbols, logos, design that distinguish one good or product in the marketplace from another. So again, the Coca-Cola logo itself is a trademark. In addition, you can also trademark, because Coca-Cola uses the shape of the bottle as part of it's a symbol, essentially. The bottle shape is a symbol that distinguishes the product from another product on itself. So even the shape can also be protected under trademark. And the interesting thing here is Coca-Cola has both a design patent for the shape of the bottle and a trademark for the shape of the bottle. And the interesting part of that is after 15 years, the design patent expires. So you can actually see over time, if you go through our database, how the shape of the bottle has gone through modifications. Still looks like a Coca-Cola bottle, but they've had several design patents on the shape of the bottle as it's matured over time. But similarly, the trademark, as long as that bottle is still used in commerce, then they can renew their trademark protection every 10 years. Whereas after 15 years of design patents, that's it. They have to either improve upon existing patents, or after 15 years, it just goes into the public domain. But since they're also able to protect it through other mechanisms, they've been able to extend the life of their protection of the shape of the bottle. All right, going back up to the top with utility patents. So let's talk about those. So utility patents can be a variety of things. It can be methods of making products, compositions of matter, and really any improvements to any of those three things. So good examples would be, let's go use the Coca-Cola example. So Coca-Cola has patents on the actual bottle dispensers. They actually just announced, it's pretty interesting, a patent application on a plastic bottle that is made purely 100% out of plant materials. So there's lots of actual composition and matter of the plastic bottle itself, patentable. And think about the conveyor systems in the manufacturing process. We grant patents on all of that stuff, so that's why we get 600,000 patents in a year. So patent terms, so patents last for 20 years from the date you file them. So if you file it today and it takes 3 years for the examiner to grant your patent, you essentially have a 17-year term. Yes? Sorry, go ahead.
I don't know if this is the right time to ask.
Sure.
Based on this time. So where do the scientific ideas come under? Is that, does the product have to be tangible in order to have a patent, or can it be a thought or an idea? Can that be patented?
So it depends, right? So what happens is, so with the patent, I'll quickly go to trademarks. To get a trademark, you actually have to demonstrate use of that mark in commerce. So if you're just about to launch a product and you file your application for trademark registration, the trademark examiner, assuming that they're going to grant the registration, if they don't see evidence that your product, and with that logo, symbol, word, or design, is actually being used in commerce, they will provisionally grant you registration. And they give you 6 months to show evidence that that mark is now being used in commerce. So there's a use requirement when it comes to trademarks. Patents give the patent holder the right to exclude others from the making, using, selling, or importation of their patented invention. It's not necessarily a right to use or to make. It doesn't necessarily give the patent holder the right to make, use, and sell their own invention, because it might require other inventions as well as part of it, but it does give you the right to exclude others from making, using, selling, or importing that invention. So what do we give in return for that? So in return for that 20-year term, that you have this limited monopoly to exclude others, you have to tell the world how to make and use that invention. And so the actual patent specification has to be enabling. So it has to be written in such clear and concise ways that somebody skilled in that technology should be able to read that disclosure and make and use your invention. So if you just have this great idea about shoes that allow you to hover, right? If your description doesn't enable someone skilled in that technology to be able to make and use that invention, then you would not be entitled to the patent for it. So if you had an idea about a certain type of clip for a binder that is enough, that you can provide enough detail that even though you didn't make and use it, it's clear to one how to make and use it, that's fine. So it really boils down to the disclosure.
Yeah, my question was like in pharmacology, like let's say there is a thought or an idea, a route to cure, let's say, a diabetic process. So that is research-based idea, which may not come out to be a tangible product unless they have gone through the R&D and FDA approval and all of those things. But till such time, where does it place? Is it
So in the bio, so you picked a really technical, complex area of patent law and biotechnology, and especially with diagnostic methods, is even more complex, or small molecules also. But in those areas, usually what happens is the applicant, the inventor, the researcher will file their application before they present it to the public. That's really important in patents. And then they subsequently will file for FDA approval. So and your point kind of is like, you don't really know the scope of the type of protection that the Food and Drug Administration is going to give you until you finish your clinical trials and all of those. So, so usually your disclosure has to kind of account for what these different variations would be, because you really want to make sure that your disclosure is solid at the time you file it, because you don't really have an opportunity to change it after that fact, unless you file a separate application. It gets more complicated. So usually what happens is the applicant will amend their claims to match the scope of the protection given by the Food and Drug Administration. It's a really complex area of pharmaceutics. Any other questions? Yes.
I was actually wondering about like Monsanto's patent for biological promoter protein formation. I know that they were using it in the university I was working at. It's been 20 years. So could they now start to sell the potatoes they were making? They couldn't before because...
Right. So, I mean, I don't know the specific answer with that one, but I'll talk about it hypothetically. But think more on the pharmaceutical side, generic drugs. I mean, the generic drugs are able to make those drugs because the patents have expired. So that's...
So they would have to like physically make a brand new motor just with the same...
So once the patent expires, it's in the public domain. So what companies do is employ a strategy. So we talked about this quid pro quo, right? You get the limited monopoly for 20 years. You have to tell the world how to make and use your invention. So why do we do that? And that's because if you want to make and use that invention as a researcher, as a competitor, or because it's fun, you have options, right? Your options are to contact the patent holder, try to formulate a licensing agreement, or offer to purchase the patent. The other option is you could just infringe on their patent and risk being sued. And then another option is you innovate around it, right? So you come up with a new way of doing it so that you're not infringing the scope of protection that they're granted through their disclosure and through the scope of claims. Patents are very much like, patents are a form of property. All intellectual property are a form of property. So think of your home, which is personal property. If you know the boundaries of your land, and all of a sudden your neighbor comes in and says, oh, well, actually, I own 5 feet in what you thought was the boundary of your land. Actually, that belongs to me. You now have overlapping claims of personal property. The same thing happens with patents. Is if you have an overlapping claim of intellectual property, there's usually some sort of legal dispute that ensues. So the scope that's provided through the patent and the patent specification and the claim for that invention, you can innovate around that and come up with new ways of doing it. So, and that's true whether you're the competitor or the patent owner. So as the patent owner, you create modifications that keep your strength in the marketplace and extend essentially your term. That's what ends up happening.
Kind of like the problem between Apple phone and Samsung phone.
There's a lot of problems with that.
So what I'm hearing though is happening for the generic drugs now is that the patent expires and the manufacturer then buys out the other companies that would make the generic version and say, we'll pay you not to make it. And then, yeah.
Well, I mean, it's...
So they're taking around, so businesses are taking around their expired patent by manipulating the business system.
Right, but at the same time, there's not going to stop someone else from coming in, another generic of making it too. So, there's obviously in the marketplace, there's a lot of different mechanisms that are used to either defend your patents, enforce your patents, or to form licensing agreements and mergers and acquisitions. Yes.
Traditionally, have these been the parameters for 226 years, or has this recently been put out in the last?
The broad scope that I'm talking about today, yeah, those are essentially the parameters. There have been modifications. So in 2011, the President signed the American Invents Act, which made sweeping change to the patent system, but it really changed kind of how you enter the patent system. We had a first to invent standard. Now we have a first to file standard, just like the rest of the world does. And we did that to harmonize with the rest of the world. So I mentioned before, you really want to file before you disclose anything. That's critically important. Same thing with entering crowdfunding campaigns or anything along those lines. You really want to make sure that you have some sort of, at least patent pending status, and there's some inexpensive means to get patent pending status early on, but you definitely want to protect yourself at least minimally before you go on the public market. All right, so how am I doing on time?
You got 20 minutes.
Wow. Okay, good. All right, so still went the wrong way. All right, so I thought I would talk a little bit about our Office of Education and Outreach and give you a sense of the types of programs that we do through our Office of Education and Outreach, as well as through our regional offices, to promote innovation and to really bridge that gap between creativity and innovation in our classrooms. And through our director of the Office of Education and Outreach, she has designed some really robust activities. So I thought I'd talk about some of them. One, we worked with NBC Learn and came up with a series of science and innovation videos and lesson plans. So all of those are available on our kids pages at USPTO.gov. The videos are really interesting, and then there's lesson plans that follow those videos. We worked very closely with the Girl Scouts to create an IP patch. This was just within the past year and a half or so. So that is one that we're also looking into doing an IP badge as well. And now the Boy Scouts want something. So we're really excited about the direction that's going and how excited students are to earn these patches and badges. So we have inventor trading cards that we use to kind of help raise awareness of prolific inventors in the United States. So you have samples. I think we have Jim West, who invented the microphone. We've got Edison, who invented everything, along with Tesla, who invented everything else. And then Ellen Ochoa, who's I think she's the first woman in space, if I'm not mistaken, and she's actually the administrator for the Johnson Space Center and a patent holder. And her husband's a patent attorney. That's fun.
Order these?
So you can actually, we have them available on our website. You can download them and print them. And I have a couple extras too, if you'd like. I also have, as far as our education materials, this is probably something, the children won't like so much, but more in-depth basics on protecting your trademarks, general information on patents, how to file a provisional application. I mentioned that we had one, a more simplified version of an application that at least gives you patent pending status. That's what we call a provisional application, as well as guide to filing that utility patent application that matures to a patent. So I'll leave these here. These are also available online as well through our independent better resources. Yes?
Can you file a patent or trademark if you're under 18?
Yes?
Is there age requirement at all?
I think our youngest patent holder is around 12 or something like that, if I'm not mistaken, something like that. So someone's got to write the check, but. So the one thing that's not up here that I'd love to talk about is we also do a Teachers Institute every year. We did it here in Santa Clara 2 years ago, and it's rotating through the regional offices, so probably about another 2 years we'll have it again out here. But we actually bring together teachers from around the country, particularly in under-resourced areas, And we spent a week with them and giving them the basics of the different components of intellectual property, also sharing some exercises that you can do within your classrooms. Those exercises are also available on our website, so definitely encourage you to take a look at those. And it's really designed as a way to enable teachers to pay it forward in their classrooms and to use these exercises in their classrooms to help encourage kids to pursue careers in STEM. Okay, so this is actually just outside of the regional office. We're in San Jose City Hall. So we actually take up the west wing of the City Hall campus. And this was a school group that came through. What you're kind of seeing is that it starts with an idea, and you can see Juno up at the top there. So my purview as a regional director is the 7 western states of the United States. So in addition to California, I do outreach and education programming in Arizona, Nevada, Oregon, Washington, Alaska, and Hawaii. And so what we did on the 4th Street of San Jose is kind of really try to build in this educational component into our space. And so we have this fact about intellectual property as it relates to every state in every one of the 7 states in our region. A couple of them are focused on patents, a couple on trademarks, and there's one on enforcement as well. And that education goes through, follows through into the regional office and throughout our space. We have, I'll get to it in a minute, actually had about 25 attorneys from IBM, patent attorneys from IBM, and we gave them a tour today and highlighted the educational components of the space, and they were as excited as when we have, junior high school kids coming through our space and giving them, a similar tour, and at least the junior high school exercises afterwards. But it was really exciting to see how engaged they were and how pleased they were with the space that we really tried to design and create for the community. So these are the 7 states. We have 4 offices now. In our 226-year history, we operated out of 1 office out in the Washington, D.C. area up until 2012. So prior to that, everyone we hired had to go into the Washington, D.C. area. And there were some years we were hiring 1,500 engineers and scientists all into the patent office. We now have 13,000 employees. 8,400 of them are patent examiners. And so we were making everybody move to the East Coast, and we recognized that we were actually not tapping into a really great talent pool across the rest of the country. So that was one of our primary goals with opening these offices. We also wanted to, in addition to the outreach and education that I mentioned across the region, we wanted to bring services that you would have otherwise only been able to get if you flew to Washington, D.C., to Alexandria, Virginia, to our headquarters to take advantage of those services. So those are things like using our space to search for patents and trademarks. We have 6 search terminals in our lobby that are the same search systems our patent examiners use every day. And so the nice thing about having patent examiners as well, they can come down and help you with that. We have an online sign-up where you can sign up for 20-minute intervals with a patent examiner, either to help formulate your patent search or to just ask general questions. And we're really there to provide assistance. We also have hearing rooms as well as interview rooms so that you can, whether it be in person or virtually, with our workforce is diversified across the country, we have these high-tech interview rooms that really replicate that in-person experience. Yes?
Do you ever, and you might get to this, but do you go into high school or anything as guest speakers?
Yeah, so we're happy to do anything along those lines. So in addition to myself, I have 2 regional outreach officers that help me with engaging the community both here and across the region. And I have a handful of patent supervisors, which are also on my team because they're good about delivering education programs for on intellectual property, primarily patents. But yeah, so we would welcome that opportunity as well. All right, yes, sorry, go ahead.
How large is the Silicon Valley office you mentioned?
So So it's like a drop in the bucket compared to headquarters. You know, we have 8,400 patent examiners, across the agency, and we'll have about 80, 85 in the regional office. So it's really only 1%, but we'll have up to about 130 employees. So it really gives us the ability to, so in addition to patent examiners, we have patent trial and appeal board judges that do some of the more advanced prosecution and challenges to patents. But it gives us the opportunity to really work with the community in a new way, even though it's not thousands of people.
You mentioned in the beginning that half of the 30% from California is from the area. Is it all like STEM related, or do you see other ideas?
So all of the patent filings have, well, the patent examiners all have, except for the design examiners, all of the utility patent examiners have, which are 8,300 something, have technical degrees. So they're either, most of them are engineers, electrical, mechanical, chemical engineers, some are industrial, some are aerospace engineers. It really just depends on the technology they're examining. But all of them are either an engineer or they have, we mentioned biotechnology. So in the biotechnology area, most of them are PhDs. We have some masters in biology, but they also have to have engineering math. So, and then we have some advanced physics, but again, with engineering math. So we really, since intellectual property law, specifically patent law, is so complex, and learning the law is hard enough, learning the technology is even harder. So we focus on bringing top talent into our doors. Oftentimes they're patent attorneys sometimes, with law degrees and engineering degrees. But we offer full tuition reimbursement for law school, but we're trained and designed to train the engineer as in turning them, an engineer, into a patent examiner. So we teach all the patent law that they need to do their jobs, and then give them the ability to grow beyond that through law. Sure.
Do you hire like kids out of college, or?
We do, yeah, we do. So, and it's, just I'll give you examples. The class that just started this past September, we had 20 patent examiners start. There were 950 applicants for the 20 positions. And of those, I think 3 are right out of college. We've been really pleased with the caliber of people entering the patent office from the West Coast. In other offices, it might be 50% or 70% new hires right out of college. We'll see that number ebb and flow, I think, over time. So as our examiners become experts, they can also work from their home. They free up the space in the office, and then we're able to backfill them and expand our footprint across the region that way. All right, so that's City Hall if you haven't seen it. So we take up that wing on the far right. This is just some pictures of kind of the inventors in the space that we have across the top, and some of the programs that we've done. The one on the left here is a bunch, I'm trying to say they were between 13 and 17, if I'm not mistaken, and they were meeting with one of the Patent Trial and Appeal Board judges, and she was explaining to them what her career has been like, and she's in our hearing room in the regional office in San Jose. And this is, these were all part of CHIPS, which is the women that are also chief of IP, so head of IPs for in-house for corporations. And Michelle Lee, my predecessor in the head of the agency, was one of the founding members for CHIPS, and this is one of their STEM programs that they do in the region. Let's see. Okay, so other questions? Because we can do an exercise. Like, do we have time for an exercise?
Got 7 minutes.
I have time for an exercise. So now you're all experts in IP. All right, so this is an interesting table exercise here. So your table will be your group. You get other forms of IP. I give some of the profiles.
Say what?
really what this exercise is intended to highlight, is everything in the marketplace, is protected for the most part by some form of intellectual property. So, take a moment on your table to talk about the product that you have, and think about, what type of intellectual property may be covered in that product. And we kind of use Coca-Cola as an example. I'll bring that slide back up. Is there a question? And why don't we just take like 5 minutes to discuss at your tables, and then we'll come back and we'll ask for a couple people to volunteer their findings. The other thing to think about is, I talked about improvements, right? So in addition to trying to figure out, is this product covered by a patent, trademark, copyright, trade secret, or is it a design patent? The other thing to think about is, how can I make it better? And so one of the line items on your activity sheet is what would improvements would you make to that? And then in the last, I think there's an error, a mistake on the last line there. It says, what is the trademark for your proposed product? I would just say, what type of intellectual property would you seek to protect that proposed improvement? So take a few minutes, I'll walk around. All right. Do we have a table that wants to volunteer to say something? Oh, we have some. All right.
Okay, we have.
Okay, all right.
We have the dry line liquid paper. We say that the trademark is its shape, colors, and logo. And no copyright. Trade secret, chemicals, paint, and ribbon. And to improve it in the future, a biodegradable plastic and refill cartridges.
Yeah. So what was the patent? Did you cover a patent at all?
We weren't sure about that.
Okay. So I would say it probably could have a design patent just for the shape.
Okay, well, that's trademark.
And you got that as the trademark, but it's only if the trademark is actually, the shape is used to define the product, like the Coca-Cola bottle. If it's used, if you saw this in commerce, would you immediately recognize it based on its shape? But you could get a design patent for the shape. The other apps and pieces, it actually has a use, right? So it's a whiteout. It's better than the ink, so there's improvement over the little jars of whiteout, right? So it's an improvement over an existing product, and it has a use, so you could definitely get a utility patent for this. So great job. Okay. You guys want to try? So I gave them a trick question. So
well, if you just look on the box, you've got the little aqua pool, and then the little R, so that's patented.
right, trademark.
Trademark.
R is the trademark. Yep.
Copyright is just this, the logo. And over the years, I noticed it has been changed where the guys, you can actually see wrinkles and stuff like that.
As Oracle got older.
It's right here. They have the ingredients, but how they make them, put them together, that's a trade secret. So,
So the other thing you could do is actually packaging. There's a whole bunch of examiners that deal with packaging. So the actual package itself, especially the envelope of the popcorn packets inside, could be patented, and they probably are. The one though, the trick is there's another form of intellectual property I didn't talk about. So, and that's plant patents. So the actual corn, if it was modified through plant husbandry, could, I don't know if it's the case for this one, but it could essentially be a plant patent as well.
How long do those last?
They're the same term as a utility patent, they just have different rules in how they're examined.
When you mentioned plant, I really thought about where they produce this, not plants, biological, but
The actual corn itself.
But the plant itself, where they make these products, would that be something that would be
It could be,
protected from
yeah,
the methods, their process?
Yeah, the process of making, the packaging, the process of making, the conveyor systems, all of that is patentable. Anyone else? We have time for one more maybe?
One more.
One more, all right.
I know people are hungry.
You were excited, you came up with an improvement. No?
We just really stayed at the improvement, so, this is a, bag handle, so that, but then we were just like, we should make it out of silicone and then make it through, hands, that you know, so like when you're making paper towel, you can put the oven,
New use,
then
right?
you could, have it nice and secure there, and then that's where we got sidetracked.
All right, good, well done. And our other table as well. So yeah, so also the material. So we give patents on, we call it the other form of software, the textiles, right? So the neoprene itself could be Velcro.
What do you do when you
Velcro was
have-
patented, so now
the
you can't
Velcro's
color.
already patented, so
Yeah.
how do you only
Well, the Velcro patent has expired, right? But Velcro is still a very strong trademark. So this is where you run the risk, and Velcro runs the risk of making their trademark become generic. And once it's deemed generic, it's no longer, they will no longer be able to enforce if someone else calls it Velcro. Right, so if they heard you say Velcro, they would say, this is not Velcro, this is a loop and hook fastener. And I'm not kidding, that's exactly what they will tell you to do. So you will never see them say it's Velcro unless it is Velcro, because Velcro will go after them. And then also it had a trademark for the company. So.
That's kind of like the idea of Xerox, so, you know.
Exactly.
quality of
Yeah.
Xerox is right, it's not.
So you're not Xerox, you're photocopy.
All right, one last question.
question, and then you get dinner.
I'll make it quick. I'm wondering if they could also try to utilize it in a way that, to get around Velcro by using maybe textured plant fibers.
Sure.
to
There
do
are
that.
a lot of patents on hook and loop fasteners.
Yeah.
So there's an entire, like I talked about the shoes, remember Thomas Jefferson kept them in shoes? We ended up creating something as like the Dewey Decimal System for invention. Our classification system is thousands of pages long. It's got, I think over 100,000 different subclasses. So there is one or many just on hook and loop fasteners. So yeah, we have one for drag and drop for drastic so you'd be surprised. For 600,000 applications a year, we get to that. We have to figure out a good way to find that stuff. So. All right, well, thank you very much. Enjoy your dinner. It's been a pleasure.